There was just one final reference in Stringer that I wanted to go to, which was in the opinion of the Advocate General. It's at page 955, letter F. And it relates to the question of the amount of pay during annual leave. And it's part of the Advocate General's legal assessment addressing the argument that a worker on sick leave is better off on annual leave than when they're on sick leave. And it just at letter F, furthermore, a worker taking annual leave is quite often put in a better financial situation than if he were on sick leave, since during his annual leave he enjoys the right to continued payment of his wages under Article 7.1 of Directive 2003/88 without any reduction, whilst his right to continued payment of wages in the event of illness under the relevant national rules is only a fraction thereof. And it's made clear at the end of that paragraph that the contractual arrangements were 6 months on full pay, followed by 6 months on half normal pay, but on annual leave, normal pay without any reduction.
Yes.
Can I come back just very briefly to a point my Lord Brown raised first thing this morning about those who are on maternity leave or who are pregnant. I've taken some instructions on this under the employment guidelines. Employees on maternity leave are entitled to statutory maternity pay, which is paid by the pay office. It's 90% of normal weekly earnings during the qualifying period for the first 6 weeks, and then the standard rate set by the government thereafter. The only other document which may assist, or the only document that you have before you which may assist on this, is at page 253 of the appendix.
And
253. And I think this is what I was looking for earlier. It's paragraph 4.3, payment whilst on ground duties. That is pregnant employees who are grounded for health and safety reasons during weeks prior to confinement, when the pilot's prohibited from carrying out normal flying duties but unable to claim maternity pay. She will receive average earnings as agreed between British Airways and BALPA on condition she makes herself available for suitable ground duties.
sorry, so
it's an average earnings.
this is the contractual.
Yes, this is the memorandum of agreement.
Yeah.
Yes.
So sorry, how does it work? So
Well, the moment she thinks she might be pregnant, she's got to notify and she's grounded.
Yes.
For health and safety
For health and safety reasons.
But she stays at work doing ground duties.
Yes.
Until she takes her maternity leave.
Yes. And indeed, there was a case that was considered in the Employment Appeal Tribunal called Moore and Bottrill, which is referred to in the judgments of the Employment Appeal Tribunal were taken to it, which dealt with issues under the Pregnant Workers Directive and the domestic regulations, and which laid out a principle of normal remuneration there also. The view of the courts below was that that did not greatly assist them in relation to the current issue, but that is the position.
And our average earnings, do they have regard to flying pay supplements?
Yes. As I understand it, they are average earnings which take into account supplements and indeed the taxable element of time away from base allowance.
I mean, that's agreed, is it? I mean, do we know that, do we?
Well, I understand that that's the position, because that was the position following Moore and Bottrill in relation to not specifically flying pay supplements, because that was a case concerning cabin crew. Lord, I think rather than go into the detail of this, I would prefer, if I may, to ensure that we have the authority before your lordships tomorrow morning, and you can see precisely what the background to this is, unless Mr. Jeans and I are able to reach agreement that flying pay supplement and average and TAFB are taken into account.
Yes, how it works is that the scheme incorporates section 221 to 224, so that you get the pay which sections 221 to 224 dictate, which the lower courts, I think, didn't find very helpful in relation to this issue, where sections 221 to 224 are not incorporated.
Well, there may be some difference between us on this. My instructions are that flying pay supplement and TAFB are part of the incorporation. It may be by reason of the way that sections 221 to 224 operate, but it's not just on the basis of basic pay. Indeed, that was the argument in Moore and Bottrell, but perhaps we can come back to this.
Are we talking about the same thing? Are we talking about pay while grounded or maternity pay?
No, talking about pay while grounded. That was the Moore and Bottrell point,
yes.
was when grounded.
And then you go on to maternity pay, which this seems to deal with too, does it, under 4.4?
Yes, statutory maternity pay is there dealt with, ordinary maternity leave, and then it says see Employment Guide EG 403 at the bottom of the page for full details. Now, EG 403, I'm told, provides that statutory maternity pay is paid at the rate of 90%, which is the standard statutory rule, but 90% of normal earnings.
And normal, again, would include these various supplements?
I understand so. But again,
I mean, it would be quite
yes,
nice
I'm very
to have
happy
all
to
this down on a crisp piece of paper.
Yes, we'll certainly look at that overnight and seek to get something together and see if we can agree it with Council for BA.
And then if you take your annual leave, having had a period of pre-confinement and maternity leave, you say, then you forget you've had all that and you just look at the position as if you hadn't had your baby.
Yes, annual leave, you have your normal remuneration.
Because, I see. Yeah.
It's an entirely separate scheme from the maternity leave scheme. Can I then come on to the next stage of my submissions, which relates to the interpretative obligations? It's not in dispute, of course, between the parties that national law has to be interpreted so far as possible to achieve the result pursued by the directive. We have included leasing in the authorities' bundles, but I'm more than aware that your lordships probably know it perhaps nearly off by heart.
Unless there's anything that you really think we ought to see in it.
It's paragraph 8, and it's I'm sure very familiar to you. Can I, however, go to FIFA, which does spell out, which is at tab 40, which does spell out in a little bit more detail the interpretative obligations. Again, I don't think the facts really assist on this submission, nor indeed detract from it, but it's the passage in FIFA which starts at paragraph 110 and summarises the obligations. 110 is simply summarising the von Coulson and Marleasing interpretative obligations. 111, it's the responsibility of the national courts in particular to provide the legal protection which individuals derive from the rules of community law and to ensure that those rules are fully effective. A fortiori, the case when the national court is seized of a dispute concerning the application of domestic provisions which, as here, and I would impose, as in this case also, have been specifically enacted for the purpose of transposing a directive intending to confer rights on individuals, the National Court must, in the light of the third paragraph of Article 249 EC, presume that the Member State, following in its exercise of the discretion afforded it under that provision, had the intention of fulfilling entirely the obligations arising from the directive concerned, and we do rely on that principle. Then there's the von Coulson-Marleasing principle set out at 113, And then at 114, the requirements for national law to be interpreted in conformity with community law is inherent in the system of the treaty, since it permits the national court for matters within its jurisdiction to ensure the full effectiveness of community law when it determines the dispute before it.
I'm sorry, which paragraph you just read?
114.
Thank you.
And, my Lord, I don't think I need trouble to go to any of the other paragraphs. And then finally, in relation to the interpretative obligation, there is the case which we put before the court this morning, the case of Gaydan. I should give notice to Mr. Jeans of this last week, so he knows I'm going to refer to it. 2004, 2 appeal cases, page 557. And can I simply summarise the head note in this way? It was the case which concerned whether persons in...
I think we're all pretty familiar with what it was about.
Thank you very much. So it was looking at the interpretation, specifically the interpretative exercise in the light of Section 3 of the Human Rights Act and the requirement that all legislation should be read in a way compatible with convention rights so far as it's possible to do so. And I simply wanted to refer to 2 passages, if I may. First of all, at paragraph 44, page 574F, in the opinion of Lord Steyne. Where he says it's necessary to state what Section 3.1, and in particular the word possible, does not mean. First, Section 3.1 applies even if there's no ambiguity in the language, in the sense of it being capable of bearing 2 possible meanings. The word possible in Section 3.1 is used in a different and much stronger sense. Secondly, Section 3.1 imposes a stronger and more radical obligation than to adopt a purposive interpretation in the light of the European Convention on Human Rights. Thirdly, the draftsman of the Act had before him the model of the New Zealand Bill of Rights, and then paragraph 45. Instead, the draftsman had resort to the analogy of the obligation under the EC Treaty on national courts, as far as possible to interpret national legislation in the light of the wording and purpose of directives. So Section 3.1 being treated as the same interpretative obligation as the Mar-leasing obligation. And then Lord Nichols at paragraphs 29 and 30.
I don't really understand what this point is going to, because I'm not aware. Is it really argued that if European law has a clear meaning, then it's impossible to construe the domestic regulations consistently with that meaning, because they're inconsistent with it? They use the same wording. So, I mean, it seems to me that this is a non-point at the moment, unless I'm told the contrary.
Well, Lord, certainly that's our submission, but much of the respondent's case is focused on the intention of Parliament, the legislative intention of Parliament.
Yes, I think
in
so.
the
There
domestic
may be an
law
argument to think
context.
that the domestic law is flatly inconsistent with the directive, and so we can't interpret it consistently if the directive has a meaning which favours you.
Certainly, much of the submission made by the respondent appears to focus on legislative intention, and we rely particularly in paragraph 30 of Gaydan on what Lord Nichols says, that in the ordinary course, the interpretation of legislation involves seeking the intention reasonably to be attributed to Parliament in using the language in question. Section 3, and we say, in the same way, the Mar-leasing test may require the court to depart from this legislative intention, that is, depart from the intention of the Parliament which enacted the legislation. Lord, I rely on it only insofar as I make that submission, and perhaps I need to wait and hear what the respondent is going to say, but I understand that they are relying on a domestic interpretative approach.
Just to recap on what you said, we're construing Regulation 4, is that right?
Yes.
And the directive, the relevant provision of the directive,
Yes.
which directive?
It's the aviation directive that you're looking at, and the expression of paid annual leave there, but also that's 17. But the same expression, of course, as is used in the Working Time Directive, and we say you cannot simply isolate the Aviation Directive.
But the Aviation Directive is what, clause 3 of the agreement, and
Yes. Yes, clause 3 of the agreement and its implementation through the directive itself, and then, of course, the European Court of Justice authorities, which set out the meaning of paid annual leave. That's all part of the European
in each case the
jurisprudence.
expression is entitled to paid annual leave.
Yes,
And you say the European Court has given a meaning to paid annual leave.
yes,
That we should construe the regulation as having that meaning.
Yes.
Is that right?
Yes.
And it's as simple as that.
simple as that.
So all we've got to do is read paragraphs 58 to 62 of the case we looked at before the adjournment, and that's it. And that's your case in a nutshell. I don't say there's anything wrong with it.
It's certainly our case in a nutshell, yes. Can I then just finally pull together my submissions, if I may? And I shall...
I mean, all Gaydon does is to tell you that you can, so to speak, torture the language of the domestic legislation equally in order to do a MAR leasing as you can to do a Section 3.
Yes, it's exactly the same test.
Yeah.
Even
Same
if the intention of Parliament, even if the intention of Parliament appears to be
Right.
one thing, you can interpret it in a different way.
But you say there's no question of torture
Yes,
at all.
not
They're
much
the same words.
Same words, yes.
Absolutely, but I mean, if and insofar as the case is of any relevance
Yes.
at all, it is for that purpose.
Yes. It's for that purpose. Can I then draw together my submissions really just following the shape of our case? And first of all, the submissions on the required level of payment for annual leave. And we say that as a matter of community law, it's absolutely clear that paid annual leave requires normal remuneration to be maintained. That echoes the wording, that is normal, echoes the wording of the ILO Convention. The purpose of payment is to ensure that the worker is in a position comparable as regards pay to the position while working, and that is achieved by paying normal pay. We say that that accords with the ordinary natural meaning of the words as a matter of domestic law, but there's no need for a finding to that effect when the community law is so clear and where the interpretative obligation requires that the domestic law should be interpreted in accordance with community law. We say that the requirement that the worker should receive normal remuneration is not a broad general principle. It is a community law concept. And we have included in Authorities Bundle 3 the case of Jaeger, and I wonder if I could go to that very shortly. It's the last case I'm going to refer to. Tab 38. And it's a case which involved doctors who were on-call duty, and the issue was whether when they were on-call duty but not working, the employer could call that rest time rather than working time. And the particular passage on which I rely is paragraph 58 of the judgment, which is at page 1555, letter B. Where the European Court of Justice is looking at the concepts of working time and rest period. In any event, the concepts of working time and rest period within the meaning of the directive may not be interpreted in accordance with the requirements of the various legislations of the member states, but constitute concepts of community law, which must be defined in accordance with objective characteristics by reference to the scheme and purpose of that directive. And then at 59, accordingly, the fact that the definition of the concept of working time refers to national laws and or practice does not mean that the member state may unilaterally determine the scope of that concept. Thus, those states may not make subject to any condition the right of employees to have working periods and corresponding rest periods duly taken into account, since that right stems directly from the provisions of that directive. And we submit that that paid annual leave is an analogous community law concept. Working time, just like annual leave, can be in accordance with national legislation and or practice, but it's made clear in Jaeger that the national law and or practice cannot in any way dilute the community law concept, so we rely on it solely by way of analogy. So we submit the concept cannot be open to reinterpretation by the national courts, and that the UK is not free to define paid annual leave as it wishes. Paid annual leave does not mean anything different in the Working Time Directive and the Aviation Agreement. The levels of pay required are the same, and we say that for 6 reasons. Firstly, the Aviation Directive and the Working Time Directive are part of the same scheme of employee protection based on health and safety and working time.
Based on the same what?
Same scheme of employee protection based on health and safety and working time. Part of the same labour law code. Secondly, the language in Clause 3 is identical to the language in Article 7 of the Working Time Directive. And we submit that it is really unthinkable that paid annual leave should mean different things in 2 different community instruments within the same working time code. Thirdly, we rely on the fact that it's all part of the same fundamental social right. It's logical it should be the same for all categories of workers. And we refer, amongst other matters, to the ILO Convention. Fourthly, we say that the commonality of meaning as between the Working Time Directive and the Aviation Directive is underlined by Directive 2000/34, that was the amending directive, and the extension of the ordinary Working Time Directive right to paid annual leave to crew members. So the amending directive included mobile workers, which included those in air transport. And that was a right from which there could be no regression. And that's Preamble 16 and Article 2.2 of the Aviation Directive.
This extremely useful summary, I've no doubt, is written down, but not, I think, in your printed case. I wonder if possibly it could be made available to us tomorrow morning.
Oh, my lord, certainly.
That's the third piece of paper you've been asked for.
Yes. Most of it's in our printed case.
Well, I know, but it's
point may
extremely
not be,
helpful
so-
to have it tabulated
Of
crisply
course.
and well formulated as now, right or wrong.
The qualification on your last point is that the 2000 directive, tab 16, does in fact say in the recital specific standards laid down in other community instruments relating, for example, to ... annual leave should take precedence over the provisions of the Working Time Directive as amended by this directive. So, I mean, you've got an extension subject to a qualification.
Yes, but none existed at that time. That's the basis on which I make this point. At that stage, there was no other community instrument applying to workers in air transport. This is the
yes.
only place where they're included at that point. It is then superseded, but at that point, this directive applies to air transport, mobile workers in air transport, and there is no other directive applying to them.
But not Article 7.
Yes,
Is that right? Article 7 does apply. Yes,
Article
I see.
7 does
Yes,
apply.
yes, it does.
So
Right.
under this directive, they're brought
Yeah.
within the working time regime, and then a matter of months later
They're taken out.
taken out of it into a separate regime. But that separate regime does not allow any regression. That is, there cannot be lesser rights.
I mean, the reality is presumably that they knew perfectly well that, yes, the aviation agreement would be given effect, because the aviation agreement is in fact predates the 2000 Mobile Workers Directive.
Yeah, yes, it does. But what they appear to be considering at that point, at the time of June 2000, is that certainly in relation to annual leave, because of course the other articles are excluded, but in relation to annual leave in Article 7, that mobile workers are going to be brought within the ordinary working time regime. Otherwise, there would have been no point in referring to them at all in that directive, but they do. They bring them into that directive.
It's all a bit unreal because that directive doesn't have to be brought into force for another 3 years.
It doesn't have to be implemented by the member states, that's right, for another 3 years.
I mean, they were, yes, but I see your point, that you say that at that stage they weren't contemplating that the other community instrument would deal with annual paid leave.
Yes. And then, and the aviation directive itself then of course defines some things differently from the working time directive, but annual leave is the same as in the working time directive. And I will put this into certainly I'll put these key points into a note to hand in tomorrow morning, but the preamble also, of course, talked about expanding the right in relation to annual leave and adapting the other
The
rights.
difficulty is that the 2000 directive clearly contemplated that there would be other community instruments which would affect things which it was dealing with, such as paid annual leave, because it says so. Directives shan't apply where other community instruments contain more specific requirements. There weren't any at that stage, but they must have contemplated that there would be shortly.
There were some, because I think the seafarers were already there by 2000. But what seems to have been contemplated in relation to air transport was that the ordinary expanding rights would be kept within the working time directive framework, but that there would need to be adapted rights for those workers, and therefore they were outside the framework of the working time directive. And it's from that there can be it's from the annual leave that there can be no regression, we submit. Fifthly, just in relation to my key points, we submit that there's no evidential basis at all for asserting, as the respondents do, that those negotiating the aviation agreement intended the provision for paid annual leave to mean something different from the same expression in Article 7 of the Working Time Directive. It was open to the negotiating parties to agree, for example, that pay in respect of annual leave should be determined by collective agreement. But they didn't do so. That, of course, would still be subject to the principle of normality. But your lordships and your ladyship have seen that there are cases where collective agreement is referred to, relevant agreement, including collective agreement, but that was not done for paid annual leave. And sixthly, BA accept that the Aviation Directive and the Working Time Directive have the same purpose. Now, the respondent, we understand in the alternative to its submission that paid annual leave means different things in the two different directives, is also saying that the member states have a discretion to introduce regulations which provide for pay which is less than normal pay. And we say that that is not the case, Firstly, because the right to paid annual leave is a community law concept which cannot be reinterpreted by member states. And the detailed implementing provisions cannot go beneath the guaranteed threshold. The respondents say that recital 12 in the preamble to the Aviation Directive allows member states to define terms which are not defined in the agreement. And your lordships want to go to it, it's tab 17, bundle 1, preamble 12. But member states are free to define terms which are not defined in the agreement, provided the definitions are compatible with the agreement. We submit that does not assist BA, firstly because the UK has not defined paid annual leave in any particular way. What it has done is simply to track the wording of the aviation agreement, and we submit that can't be wrong. Paid annual leave has to mean the same in the two instruments, and any definition which sought to define payment for annual leave as anything less than normal remuneration would not have been compatible with the right to paid annual leave under the agreement. So, my lords, in short, in relation to the meaning of paid annual leave, we submit that the position is clear, it's as we've submitted, but that if the court considers that there is any doubt about the meaning of paid annual leave in the aviation agreement and that it might mean something different from paid annual leave in the directive, then an appropriate question should be referred to the Court of Justice to clarify whether paid annual leave bears a different meaning in the aviation agreement, and if so, what it does mean. And similarly, there should be a reference if it's thought there may be a discretion left to the member state by the Aviation Directive, which enables paid annual leave to be defined in a manner different to its definition under the Working Time Directive. Just dealing shortly with the domestic regulations, if the court accepts as a matter of community law interpretation that paid annual leave in the aviation agreement and directive does mean that normal remuneration must be maintained during annual leave, then we submit that the aviation regulations must be interpreted in the same way, according to the ordinary principles in mar leasing. We submit that the intention, a test as the intention of Parliament, does not assist, but even if it did, BA's assertion in its case that where the European level standard is set in a collective agreement, that is the European agreement, Parliament deliberately decided not to lay down a minimum standard, we submit is no more in this case than an assertion. Firstly, because there is no evidence to support that, where there's been nothing produced from Hansard or anything that would support such a submission. But secondly, that if Parliament had intended that the level of pay would be defined by collective agreement, it would have said so. I come finally then to my submissions on the requirements of national legislation and/or practice. And again, just pulling together really the threads. Two questions we submit arise in relation to this. Is the concept of paid annual leave without further definition in national legislation insufficiently certain? That appears to be the first point that's taken against us. If the meaning of paid annual leave is sufficiently certain, does there need to be a formula in the domestic legislation for calculating pay for the purposes of paid annual leave? We've already addressed at some length, and I shall endeavour not to repeat. It is sufficiently certain. The ECJ in Bectu says it is. The ECJ in Robinson, Steele and Stringer defines what it means, and it's clear from community law what paid annual leave does mean. If the domestic legislation simply repeats the exact words of the directive, what greater certainty could there be, we submit? In relation to the second argument, and that relies on the question of whether there needs to be a formula in the domestic legislation, BA has accepted, and the Court of Appeal upheld, that there were circumstances in which a remedy would be available under the existing domestic provisions. And that was circumstances in which an individual was not provided with any pay in respect of leave, or was provided with pay which was only token or derisory, so that the individual employee was deterred from taking leave. That was BA's submission, and that was accepted by the Court of Appeal. We submit that if the aviation regulations can provide a remedy in those circumstances, then they must be capable equally of providing a remedy where payment during annual leave falls below the level of normal remuneration. In many respects, calculation of remedy where only token or derisory payment is made would be very much more difficult than where normal pay was claimed. Every case would have to be looked at individually on its facts. The contention that there is a need for a formula by BA is essentially a contention which has to lead to the result that the UK is in breach of community law for failing to provide a formula. That is, as the Court of Appeal put it, that the cases fall into a void. That would mean that the principles of effectiveness and equivalent have been breached. And we've included in the bundle, but I don't propose to go to it because I think it's a very well-known passage. The case of Hanson, it's in volume 2, tab 35, and the relevant part at paragraph 17 for your note. But we submit that the court should only reach the conclusion there's been a failure to implement the directive if such a result just cannot be avoided. It's the duty of the national court to avoid, by interpretation, a result which involves a breach of community law. And there's no need at all in our submission to reach such a conclusion in the current case. As we set out in full in our case, Regulation 18, I took you to it when I was opening. I don't propose to go back to it unless you would be assisted by going back, but essentially it provides for a remedy by way of declaration, compensation, and compensation to be assessed on a just and equitable basis. So that there's no need for any gaps to be filled. The right is there and the remedy is there. The right to paid annual leave is there, and a remedy for breach of that right is provided in Regulation 18. And I simply remind you that the right is the composite right, annual leave and payment for annual leave. So the assessment of remedy is no more complicated, we've submitted, than in cases where you might be dealing with breach of contract or unfair dismissal compensation. You may have to carry out some sort of averaging process, but that's something that courts and tribunals are well able to do. And so finally, just on this point, again, it's our submission that the law is clear, that it can be interpreted in accordance with community law to provide a remedy. But again, if you consider that there may be any doubt as to whether the requirements of national legislation and or practice can allow a member state to provide remedy for anything less than normal remuneration, then again that's a matter that may need to be referred if there is a need for a formula. Lords, those are my submissions.
Thank you very much. Mr. Ford? No. Yes.
Lords and ladies, can I start by giving you BA's case in a nutshell? And I'll put it in under 4 paragraphs. 1. The issue, which your Lordships and your Ladyship have to decide, is one of construction of UK regulations, the civil aviation working time regulations, which I'll call the aviation regulations. You have to construe UK regulations. 2. As a matter of domestic construction, at least, the meaning of those regulations in the present case is crystal clear. Pilots who
I'm sorry, I missed that word.
I'm sorry, pilots?
Pilots, yes, sorry.
Sorry. Pilots who have more than 4 weeks leave on full basic salary in accordance with collective agreements are receiving paid leave of at least 4 weeks. So that's plain as a pikestaff. 3, the Civil Aviation Working Time Directive, which I'll call the Aviation Directive, A, does not lay down prescriptive rules for the computation of leave pay.
For the computation of
Leave pay. B certainly does not require the inclusion in leave pay of some element for allowances which might or might not have been received if the pilot was working. I'll develop that in due course, of course, but your Lordships and your Ladyship will have the point instantly. The allowances we're looking at in the present case will be payable in some weeks, but not in others. Depends whether you're flying, whether you're away from base, and you'll recall the finding that only 15 days a month, on average, are actually flying days. So, when one goes to the European cases, you'll see that there's nothing in the European cases which tell you that irregular allowances must be included as part of normal pay. Still less, what allowance, if any, should be made for such irregular payments. Again, foreshadowing the argument, much of Ms McNeill's very skillful submission on this assumes one of the very questions to be decided. She says the claimants must be paid leave pay comparable to the pay they receive at work. But that begs the question, what work? And seen in terms of normality, over what period? does one judge normality and what process of averaging is to be undertaken? There's nothing in the European cases that tells you that allowances of this kind must be included in normal pay.
Isn't it a bit odd to say that aviation workers don't normally fly?
Well, one has to look at the facts. The facts are that they only fly half the time.
I know, but they're employed basically to fly. The reason they don't fly all the time is partly, no doubt, logistical, partly because they need rest and they work very hard when they are flying.
It's clearly an important task, but what the European cases don't tell you is anything about irregular allowances. And one can think, and I'll develop this in due course, one can think of all kinds of payments which might be paid occasionally, most of the time regularly, according to circumstances. Payments for particular working conditions which are only occasionally encountered, or for particular inconveniences which are only encountered. And
routinely, presumably, overtime would be a classic case. There are some periods, police and heaven knows everybody else, when they're going to be working a huge amount of overtime, others not.
Absolutely.
But is your submission on I know it's not under the aviation directive, but in their case, presumably their overtime is factored in.
No, their overtime isn't and wouldn't be under the English provisions, sections 221 to 224. The rule under those provisions is that overtime only counts if it's guaranteed. And when we go to those provisions, as we will in due course, what one sees is that it is absolutely essential to have a series of rules, very detailed rules, which regulate these matters. How does one deal with irregular allowances? How does one deal with overtime? What's the reference period? In what circumstances does one average? In what circumstances does one discount? And the Civil Aviation Directive simply doesn't address these questions, but instead, and this is my 3C if I haven't lost the plot altogether,
No, there you are.
instead leaves discretion to member states as to how leave pay is to be computed. We say the directive does that in terms, and the directive simply doesn't advance the position from the domestic meaning of the regulations, which, as I've submitted at 2, is plain and obvious. These individuals do receive 4 weeks paid leave. 4, I'm still on my nutshell, even if, contrary to our submissions, the directive did lay down prescriptive rules for computation of leave pay, it would not be open to the court, A, to write in such rules as a matter of interpretation, because this would entail creating a scheme which Parliament has not provided. This was the view of the Court of Appeal, and we say they were right. It would mean having to write in some equivalent or shadow scheme to sections 221 to 224, and that simply can't be done as a matter of interpretation. And we too will take you to the Gaydon case in that connection. B, and this is the very end of my nutshell summary, even if the directive did lay down prescriptive rules, it would not be open to the court to apply the directive directly against BA. And that aspect of my submissions is, I think, common ground. So we say the domestic meaning is clear, the directive allows discretion and doesn't contain any prescriptive rules which prohibit the payment of basic pay for leave pay, but even if they did, it would be impossible to interpret the English rules to incorporate some scheme shadowing sections 221 to 224, or to apply the directive directly against BA. So that's the general structure, and may I go to those elements in turn. Our first and simplest point is that the issue is an issue under the English regulations. The regulations which you have at tab 10 of the authorities. And just to focus on it, if we may, just for a second, question the court is by now very familiar with.
I bet they're UK regulations, aren't they?
They're the UK regulations.
Not English. A cheap point, Mr. Jeans, but
Yeah.
we don't have any of our Scottish colleagues here, so I'm standing in for them.
There's certainly no translations into the Scottish.
Well, they don't. Yes, 16.2 doesn't apply in Scotland, so
Right.
the rest presumably do.
At all events, goes to regulation.
It's a domestic.
If I can address Scotland and Northern Ireland tomorrow, perhaps. Regulation 4, a crew member is entitled to paid annual leave of at least 4 weeks. The question, therefore, is whether the pilots who receive around £2,000 a week, over 4 times the median average pay of a British worker.
What's the relevance of that?
Well,
This case could just as well have been brought by Unite, couldn't it?
Well-
For much lower paid workers.
it could have done, but these are the facts that the court has to confront. And the broad question, which is the simple question in the case, is whether they are receiving paid annual leave of at least 4 weeks.
And that depends upon what's meant by, quote, paid annual leave.
It does. The paragraph 10 of the facts and issues confirms that at Gatwick they get 42 days, of which 35 are compulsory. Elsewhere, 30 days plus 30 days compulsory plus 2 duty-free weeks. Long and the short of it is they get well over the 4 weeks. And the tribunal found at paragraph 26 that they were entitled to more generous leave than required by the regulations, and it's common ground that they take that leave and indeed are required to take it. The only question, therefore, is whether that leave is paid. And we say that it plainly is. If you ask a pilot, is your leave paid? I would respectfully suggest that he will respond with a testy, of course. He might say, I should get more, I don't agree with what the union negotiated on my behalf. But he wouldn't say, it's not paid leave that I receive. And so our fundamental submission, which we'll come back to at the end, our fundamental and basic submission, is that the meaning of the UK regulations is plain and simple. This is paid leave. And in our case, paragraph 25, we refer to the familiar judgment speech of Lord Mackay in the Hayward and Camel Laird case. Don't perhaps need to turn it up, it's at your authorities bundle, tab 28, page 902. We say it's wrong to depart from the natural meaning of words Parliament has used because of the difficulty of their application to particular examples, especially when those examples do not arise in actual cases. and we say whatever arguments there might be brought in other cases, there's no doubt that what these individuals receive as a matter of ordinary English language is 4 weeks, and indeed more than 4 weeks, paid leave. Now, we do say the history is very informative. Miss McNeill, I'm very grateful to Miss McNeill for doing the job that I had to do in the Court of Appeal, of taking the court through the outline history of the directive and the regulations. There is a particular aspect that I need to tackle in a little more detail, so do forgive me for dullness if what follows is less than fascinating, but it's central to an understanding of how the regulations come to be in the form that they are. I'll try and take it very shortly. You'll recall that in the beginning was the Working Time Directive back in 1993, and you have that in Authorities tab 13 in its original form, and you'll recall that it excluded air, sea, inland waterway and lake transport, amongst other things. And it's to the seas and the inland waterways that I'll be going in a moment. Now, what happened around the turn of the millennium, to put it loosely, is that in 2 of the excluded areas, namely non-fishing seafarers and aviation, there were community-wide collective agreements which were subsequently given the imprimatur of directives. And
Subsequently given what? I'm so sorry.
Sorry, subsequently given the imprimatur of directives.
Yeah.
You've seen it in relation to aviation. I'll show you very briefly in a moment in relation to non-fishing seafarers. And what happened was that where there was a community-wide collective agreement, Parliament, well, first of all, the directive required that effect be given to that agreement, and Parliament then enacted a simple obligation to allow 4 weeks paid leave without creating any minimum pay obligation and without creating any specific remedy for underpayment. In contrast, where there was no community-wide agreement, when the Working Time Directive was amended so as to bring sea fishermen and inland waterways workers into the fold, what was done was to legislate specifically for a right to minimum pay and a remedy for underpayment, which did not apply in those cases, namely the non-fishing seafarers and the aviation workers, where there was a community-wide agreement. And comparison of the regulations is instructive. Can I just show you very briefly the seafarers? If you go to Authorities tab 15, you there get the Seafarers, Non-Fishing Seafarers Directive. The Court of Appeal gave it that title, and I'll stick with it. And what that does, in a very similar way to the aviation agreement, is to append the European-wide agreement. You see it as an annex if you go over the page. There's an agreement reached on the 30th of September. And you see at the top of the agreement that the parties were requesting community action to give effect to their agreement, and clause 16 sets out every seafarer's entitlement to paid annual leave of at least 4 weeks, in accordance with the conditions of entitlement to and granting of such leave laid down by national legislation or practice. Familiar phrase. It's worth noting, if one turns to the covering directive.
Sorry, so that you say, clause 16 of that is akin to clause 3 of the aviation agreement?
Yes. It's instructive just to look at the preamble to the directive. This is a directive that's more preamble than substance. And in particular from recital 11, the proper instrument for implementing the agreement is a directive within the meaning of section 249 of the treaty. It therefore binds the member states as to the result to be achieved, whilst leaving national authorities to the choice of form and methods. And then 12, in accordance with the principles of subsidiarity and proportionality set out in Article 5 of the treaty, of which more later, the objectives of this directive cannot be sufficiently achieved by the member states and can therefore be better achieved by the community. This directive does not go beyond what is necessary for the attainment of those objectives. And 13, with regard to the terms used in this agreement which are not specifically defined herein, this directive leaves member states free to define those terms in accordance with national law and practice, as is the case for other social policy directives using similar terms, providing that those terms respect the content of the agreement. And we'll see something very similar in relation to civil aviation. So that was the Seafarers Directive. And just to stay with the theme, rather than the strict chronology, if we then go to the Seafarers Regulations, they are in the first volume of authorities at tab 7. You see at Regulation 12 the transposition of the relevant provision. Entitlement to annual leave. A seafarer is entitled to paid annual leave of at least 4 weeks, or a proportion of 4 weeks, in respect of a period of employment of less than 1 year. Leave to which a seafarer is entitled under this regulation may be taken in instalments, may not be replaced by a payment in lieu, except where the seafarer's employment is terminated.
So that's equivalent to 4 of ours.
It is. And of note is the fact that there is no provision as to the amount of pay. There is no remedy for underpayment. All there is, indeed, by way of enforcement mechanism in the case of these particular regulations is the prospect of criminal prosecution. If you go to Regulation 20, Sub-Regulation 4, where there's a contravention of Regulation 12, the employer of the seafarer shall be guilty of an offence punishable on summary conviction by a fine not exceeding level 5 on the standard scale. That's Regulation 20, sub-regulation 4. So all you have is a basic right to 4 weeks leave, but no specific provision as to computation of pay, and no remedy for
So what's your
underpayment.
remedy if you only get 2 weeks holiday? Paid leave.
Well, you have to ask for the prosecution of your employer.
Would you, there's no civil remedy at all?
No civil remedy at all.
There's nothing equivalent to 18 of our regulations.
No. But and I will come back to the significances of there being a criminal penalty for this in due course. But the point I'm concerned to underscore just for the moment.
So you say this gives no rights at all then to the individual that he can enforce in any tribunal?
There's no right of recourse to a tribunal, no.
What about breach of statutory duty?
Well, it's clearly conceivable in principle that there could be an action in the ordinary courts, but what there is not.
Well, why isn't there action in the ordinary courts? But after all, there's no criminal penalty in relation to a breach of Regulation 12. Is that?
Yes,
Yes, it's Regulation 20, sub-regulation 4.
Yeah.
I beg your pardon.
But in the absence of a provision specifying that the criminal penalty is the only right of recourse, there'd clearly be an argument that there was a breach of statutory duty.
But it's a bit unreal because, I mean, the reality is that no contract could be made which didn't provide for annual leave of 4 weeks, and so there'd be a breach of contract.
But what it shows for present purposes is that the right which is being transmuted here is a right to paid leave rather than a right to some specific minimum level of pay. It's really not imaginable that an employer of a non-fishing seafarer would be prosecuted or would be liable to prosecution because he'd included this or not, but not that allowance in computing an individual's pay. There's simply no obligation created to pay any specific minimum level. And of course we see...
I don't know, I mean, assume there's some guaranteed overtime. I mean, I apprehend that in the ordinary way you would accept that that should be included, wouldn't you, in the holiday pay?
For the purposes of these regulations, I'd say it's sufficient that the individual is paid. And there may come a point where you say, well, you can't really say that this individual's been paid because he's only received a token amount. But I would not accept that an employer of a seafarer could be prosecuted for not including the right allowances or extras, because that's not a right that's conferred by the regulation. But
Well, it all depends, as exactly the same in our case. It all depends what it means.
Well, can I just show you the difference in structure of these relevant regulations, because it is instructive. One goes to the Civil Aviation Working Time Regulations at tab 10. We've seen again in 4, what is created is a simple right to paid annual leave. Here there is a remedy created by Regulation 18, but it is a remedy which focuses on leave but not on pay. I'm going to contrast in a minute the other 3 sets of regulations, in fact. Crew member, this is Regulation 18.1, may present a complaint to an employment tribunal that his employer has refused to permit him to exercise a right he has under Regulation 4, 5, 7. You needn't worry about the rest. So the right of complaint is that the crew member has been refused the opportunity to exercise the right to have 4 weeks, or a full 4 weeks, paid annual leave. It's not a right to complain that he's been underpaid, and this is going to be a contrast.
Well, we're back to the meaning. We always come back to the same thing, namely what is meant by the expression which we've seen.
That I fully accept.
These are submissions that assume you're right.
Well, not quite, with respect. When we look in a moment, and I'm afraid I'm making heavy weather of this, as it's a little difficult not to in these seas, but what we see in a moment when we look at the other regulations is that they all have rights and remedies which assume there is a minimum level of pay which must be paid, and they have a scheme of relief which reflects that. In the case of the aviation workers and in the case of the non-fishing seafarers, all you have is the basic right to paid leave, and you don't have a specific independent right to pay.
Well, maybe the reason is that the aviation regulations apply to persons employed by undertakings established in the UK, so it's realistic to give civil rights. Whereas in the case of non-fishing seafarers, the regulations actually apply to ships, seagoing United Kingdom ships, wherever they are, and seagoing ships of other member states when they're in the UK port or UK waters. So that to start giving the crew of, Greek ships in London civil rights here, it may be regarded, because their contracts would be subject to Greek law, rather odd. But that may be the one reason why there's a slight difference. They just say it's a criminal penalty.
Yes, I'm not seeking for the moment to draw a contrast between the non-fishing seafarers and the aviation workers. I'm putting them, for the present purposes, in one pot. And I'm going to take you in a moment to various other kind of workers who've got a completely different structure.
And there may be a slight difference, you see, because the European competence can be backed up by civil penalties, as criminal penalties where necessary, but I'm not so sure it's easy to back it up by civil claims. That may be
right.
Well, it's interesting, isn't it? I have a feeling there's lots more to this. The civil aviation working time regulations were made only under the European Communities Act power.
Yes.
Whereas the merchant shipping hours of work regulation, which is a dead giveaway, is also made under the Merchant Shipping Act.
Yes.
And I suspect that tells us quite a lot about the reasons for the differences.
Yes. As I say, I'm not, for present purposes, drawing a contrast between non-fishing seafarers and aviation workers. I'm putting them in the same pot because they have, for present purposes, a similarity, which is that there is no specified minimum level of pay and no set of remedies directed at pay as distinct from leave. And you see that in Regulation 18. The right of complaint is not a complaint that someone has been underpaid. It's simply that the employer has refused to allow him to exercise the right
to paid annual leave.
To paid annual leave, but I must show you in a moment the other regulations because they strike the contrast. And then sub-regulation.
We did pick that up when we were going through it before.
Sorry. Sub-regulation 2, the time limit runs from a period of 3 months beginning with the date on which it's alleged that the exercise of the right should have been permitted, or the payment under Regulation 4.2b should have been made. Now, the Regulation 4.2b payment is the in lieu payment, and that's the only payment which is seen as triggering, or non-payment, which is seen as triggering a remedy under Regulation 18. And then 18.3, there's a power to make a declaration and a power to make an award of compensation, which I'll return, but not a specific power to award in relation to an underpayment of monies. Contrast at long last, the leadership may think. Inland waterways at tab 8.
What happened to the railways?
The railways was simply brought in, I think, to the general working time regulations. I'll come to those in a moment.
I suppose they don't have to overnight very often,
One can certainly see it.
whereas
it's
inland
more
waterways,
Many, many nights.
yes.
It depends whether they
You're
did
on
in
the
Scotland
Orient
run.
Express.
Tab 8, what one sees here is a fully detailed entitlement to annual leave and payment for leave. And draw attention first to the crosshead. It's not simply an entitlement to annual leave, it's a right also to payment for leave.
Sorry, which
We're
regulation?
now on the inland waterways.
No, I got the right regulation.
Tab 8, Regulation 11.
It's regulation 11 I needed to be directed to, thank you.
Entitlement to annual leave and payment for leave. Subject to paragraph 2, a worker is entitled to 4 weeks annual leave and to be paid in respect of any such leave at the rate of a week's pay in respect of each week of leave. And one underlines, first of all, there's introduced there, what there isn't in the other two sets of regulations, a right to be paid at a week's pay in respect of each week of leave. And then,
Well, that doesn't tell you much.
well, it does tell you that there is a rate of pay, and a week's pay is defined in terms of sections 221 to 224. You get that in sub-regulation 4 over the page.
I see.
Sections 221 to 224 shall apply for the purposes of determining the amount of a week's pay for the purposes of paragraph 1, with some amendments. And then one sees provisions about set-off in sub-regulations 6 and 7. A right to payment under paragraph 1 does not affect any right of a worker to remuneration under his contract. And then 7, any contractual remuneration paid to a worker in respect of a period of leave goes towards discharging any liability of the employer to make payments under this regulation in respect of this period. So there's specific provision that there's to be pay at the minimum level of a week's pay, and there's a scheme of set-offs. And then when one goes to Regulation 18, one finds Regulation 18.1, a worker may present a complaint to an employment tribunal that his employer A has refused to permit him to exercise any right he has under inter alia Regulation 11. Or, and this is the bit that's not in the other two sets of regulations, has failed to pay him the whole or any part of any amount due to him under Regulation 11.1. So there's a specific remedy for underpayment. And then the time limits, similarly, reflect the existence of that separate right and remedy. Regulation 18.2, an employment tribunal shall not consider a complaint under this regulation unless it's presented before the end of 3 months, beginning with the date on which it's alleged that the exercise of the right should be permitted, that's A, or, as the case may be, payment should have been made. So there again, specific reference to the making of payment, which you don't get in the first two sets of regulations. And then sub-regulation 5, where on a complaint under paragraph 1b, that's underpayment, an employment tribunal finds that an employer has failed to pay a worker in accordance with Regulation 11.1, it shall order the employer to pay the worker the amount which it finds to be due to him. So there's a provision that's wholly absent from non-fishing seafarers and, importantly, aviation. It's a specific power to award the minimum sum for which these regulations provide, and the aviation and non-sea fishing regulations don't provide. And The rest I can take shortly, you'll be pleased to hear. The fishermen's regulations, just over the tab 9, mirror precisely the inland waterways regulations. Again, it's regulation 11, which again creates the dual right. A worker is entitled to at least 4 weeks annual leave and to be paid in respect of such leave at the rate of a week's pay. Again, sub-regulation 4 says a week's pay has to be construed in accordance with sections 221 to 224. And sub-regulations 6 and 7 provide for set-off. In other words, it has all the provisions focused on amount of payment which the inland waterways have, and the non-fishing non-fishing seafarers and civil aviation workers do not. And similarly, regulation 19 creates in 19(1)(b) specific remedy in relation to non-payment, again in contrast to the first two sets of regulations. Again has a time limit in regulation 19(2)(a), which runs from the date of payment or non-payment, and has a specific remedy in 19(5) in respect of non-payment, which is separate from the right to compensation for not permitting the exercise of the right. And those provisions of those two specific regulations are the precise analogue of the working time regulations themselves, the general working time regulations, in tab 5. I think we decided it was best to look at these in the form they appear at the time of the proceedings in 2006, so that's at tab 5. Regulation 13 sets out the entitlement to annual leave. Subject to paragraph 5, a worker is entitled to 4 weeks annual leave in each leave year. Regulation 14 sets out the right to pay in lieu on termination. And then Regulation 16 sets out specific provisions in relation to payment in respect of periods of leave. A worker is entitled to be paid in respect of any period of annual leave to which he is entitled under Regulation 13 at the rate of a week's pay in respect of each week of leave. And lo and behold, subsection 2 incorporates sections 221 to 224. Subregulation 16(5) incorporates the set-off provisions, and when we go to Regulation 30, it is exactly, in this respect, like the inland waterways and the sea fishermen. There's a specific right of complaint for non-payment. Regulation 30, sub-regulation 2, says that time runs from the date when payment should have been made. And there's the same distinction in regulations 3 and 5 between a complaint that an individual has not been permitted to exercise the right to take leave, a Regulation 13 complaint under Regulation 30, sub-regulation 3, and a Regulation 16 complaint which is remediable under Regulation 30, sub-regulation 5. If the complaint is under 31B, that the employer has failed to pay the remuneration, then 35 kicks in, an employment tribunal finds that an employer has failed to pay a worker, it shall order the employer to pay the worker the amount which it finds to be due. So that very laborious process shows this clear distinction between, on the one hand, the general working time regulations we've looked at, and the inland waterways and the sea fishermen regulations, all of which create a specific right to minimum pay and create a specific remedy for underpayment and provide for set-off, with, on the other hand, the civil aviation regulations and the seafarers regulations, which just simply create a right to the minimum paid leave, do not provide for any minimum payment, do not provide a remedy for underpayment, and do not set time limits by reference to the date when payment ought to have been made.
But the real trouble is that as my Lord pointed out, it begs the question of what is the minimum payment?
Well,
Or rather, what is sufficient payment to meet the requirement?
we don't suggest it answers all the questions, but we do say it tells you several things. Firstly, as Lord Justice Reimer put it at paragraph 23, page 916 in the Court of Appeal, that
Page right.
page 916 in the Court of Appeal,
Yeah.
letter B, says the legislation giving effect to community requirements as to paid annual leave knows perfectly well how to spell out the calculation of holiday pay when it wants to. And it made a similar point at page 916. Parliament is well capable of spelling out the precise measure of a week's pay when it wants to. So, first of all, it shows you that Parliament knows how to create a right to minimum pay when it wants to. Second conclusion we draw from this highly tedious little review is that the minimum threshold and the computation rules are not included in cases where community-wide agreements exist. And this, in turn, we say, must reflect the perception that it is not necessary or appropriate in this highly unionised industry to have a minimum threshold, and that it was perfectly appropriate to leave it to the collective parties to decide what the minimum threshold should be.
Presumably you're saying that reflects Parliament's,
Yes,
the UK Parliament,
yes.
because the distinctions you're drawing aren't apparent from the directives.
No, I'm dealing, I hope, in the sort of order of my initial nutshell.
True, I was
really
merely
with
wishing to establish
the
that what you're
domestic
saying
position-
is Parliament,
Yeah.
the UK Parliament, has decided, or at least illustrates, that they don't think a minimum threshold is necessary in the two
Yes.
collectively bargained cases.
Yes, I hope I'll go on to demonstrate that community law doesn't require certainly any minimum which could be infringed in this case. But at this stage, I'm focusing on domestic intention, and unashamedly so. Again, Lord Justice Reimer at paragraph 21 makes the point that it's unsurprising that much was left to collective bargaining when the provisions themselves were the product of a collective agreement, and that the inference and he makes this point at paragraph 37, letter E. The inference is that when it implemented the directives by national regulations, Parliament chose to leave it to the industries themselves, both unionised, to negotiate matters such as holiday pay. Now when we come to the European aspect, we'll be referring to the fact that the aviation directive itself says that member states are free to define or not to define concepts in the agreement. But we do specifically adopt what Lord Justice Reimer, giving the judgment of the Court of Appeal, said, that it's really an inevitable inference when you look at this pattern and the history, that Parliament has decided to leave it to the unionised industries to make their own decisions about holiday pay, whereas in industry generally and in inland waterways and sea fishermen, where there isn't the community-wide agreement, it was thought necessary to lay down more specific rules.
Could you just remind us of the paragraph number in the Court of Appeal? Because I wrote down 47, but it can't be that.
37, letter E, I'm so sorry.
No, it's probably...
And you also referred to 21 in this context, did you?
Yes.
Yeah.
And is 21 right?
I'm wondering.
I was a bit puzzled by 21.
Yeah.
21 may not be right. 37E is definitely right. If I'm wrong about 21, I apologise.
21 is the contrast
Yeah.
between the sets of regulations.
Yes, it is. Sorry, it's 23. It's summarising a point I make, but it then goes on to say it agrees with that point. And the longer quote is the one that I read from paragraph 37.
And where does he agree with it? Paragraph 37, you said?
Yes.
Well,
This
Is
is
that-
where I picked up the point that Balbrony started shouting when you not
Yes.
spotted it.
Yes.
but is paragraph 37 are these his conclusions or are they your submission?
There are submissions which are accepted.
I'm not saying they're not suggested, I'm just wondering whether it's in paragraph 37.
Yes, they are submissions which are accepted.
I think 65 picks it up.
Ultimately, it's
An airline employer which, for example, offered
yes,
either unpaid annual leave or a token or derisory amount.
yes. And there's the rejection of Miss McNeill's arguments to the contrary between 58 and 64.
But you're saying, as I understand it, that it's not just a matter of, in practice, of negotiation between employer and employee. This is pay which is fixed by industry agreements of the obscure nature we haven't got in detail before us.
Well, certainly in the case of these pilots, it is fixed by industry agreements. And these pilots are, of course, represented by the European...
But not we haven't got the cross-European agreements, though, or at least beyond what we have in the recital to the European agreement.
No, well, we've got the general European agreement, obviously, that's given effect to in the directive. But the broad point is that this is a highly unionised industry and was seen to be,
Yes,
and it was not thought necessary to have the degree of intervention or specificity which was applicable to other industries or indeed to industry generally. It's the only conclusion one can draw from the fact that in these two cases, the non-fishing seafarers and the aviation workers, The only conclusion one can draw, from the exception of those two cases, is that Parliament did think it was significant that there was community-wide agreement, and it elected not to legislate for a minimum pay provision, and not even to legislate for a remedy in relation to underpay, but simply to create a single right to paid leave, and to provide that there was a remedy, in the case of aviation workers, for a refusal to allow that right to be exercised.
Is there a reference anywhere in the domestic legislation to, for example, the collective agreement constituted by the Memorandum of Agreement between Balfour and BA, that sort of agreement? There isn't at the European level, is there? They just talk about the general European agreement, which is no more specific than to require paid annual leave, but does anything refer to the
the exclusion in the working time regulations as amended, if one picks up tab 5 of the authorities bundle, it's regulation 18. We looked at this very briefly earlier with Miss McNeill. 18.2 regulations, and then the important ones are 13 and 16 for present purposes. Yes. 13 is leave and 16 is pay for leave. Do not apply, and then little b, to workers to whom the European Agreement on the Organisation of Working Time of Mobile Staff in Civil Aviation completed on 27.
But again, that just simply refers to what is enacted by the Aviation Directive. There's, what I was looking for, you say that the purpose of the domestic legislation was to leave pay to collective agreements such as the MOA between Balfour and BA, but are they ever anywhere referred to?
No. But we say it's really an unavoidable inference when you look at the two groups that do not have the equivalent of regulations 13, 16 and 30. And they are the two groups who enjoy community-wide collective agreements. It's really an inevitable inference that Parliament decided to treat those groups differently.
But, sorry, I may be forgetting something here. But don't we have a general working time directive from which various groups are excluded, including these two groups, and including the other groups, the fishermen and the inland waterways? And then what happens is that the fishermen and the inland waterways are brought into the general directive by the amending directive. But there is a lex specialis provision in the directive, and there are then two leges specialis. In other words, the two specific directives, and they are legislated for domestically by the two sets of regulations. So it mirrors, as I understand it, the pattern of the European directives, which, although they do have very minor differences between them, actually all use the same concept.
Yes.
So Parliament might just have been saying, right, well, we've got to do this one now because they're the directive, we better do something about it. Let's do it this way.
Why do they not do the same for aviation workers and non-fishing seamen? The only inference can be because there's a different background. They are the subject of community-wide agreements, and we say it's really an inevitable inference that Parliament took the view that it wouldn't be appropriate.
But the community-wide agreement is that in clause 3, isn't it?
Yeah.
And clause 3 says mobile staff in civil aviation are entitled to paid annual leave of at least 4 weeks. So the parties to that agreement left it to the European Court to decide what that meant. It's
Well,
like many trade unions.
But it must depend upon the other bits of your argument about how much discretion is left.
This isn't as where a freestanding point, but it does, in my submission, point up that what's happened here is no accident, is a deliberate decision because of a different collective background.
Mr. Greens, it's my fault, I'm sure. I mean, we were looking at 8 Regulation 18 of the amended 1998 Working Time Regulations, tab 5, right?
Yes.
And excluded sectors 18(2)(b) deals with our European agreement as to the civil aviation people. But where's the equivalent in respect of the non-fishing seafarers?
They are in 1A. These regulations do not apply to workers to whom the European Agreement on the Organisation of Working Time of Seafarers, dated the 30th of September 1998.
But, I mean, some regulations apparently do apply, at least, to the aviation people, although none to the seafarers, is this it?
Yes.
What's the logic of this?
Well, it's not easy to see because nearly all the operative regulations, apart from one or two concerning records and youth workers, are in the list of excluded regulations. So I must say I've scratched my own head about this. But for present purposes, obviously, we're concerned with leave and pay for leave. And in that respect, the exclusions cover both. And we do say that I've made the point already in passing that there is no reason why paid should be different as between Regulation 4 of the aviation regulations and Regulation 12 of the non-sea fishing seafarers regulations. But if the claimants are right, the employer of a seafarer is exposed to a criminal penalty if he pays an amount with which a magistrate's court, applying its own rule of thumb, subsequently disagrees. The magistrate's court thinks they ought to have got more because some allowance is not included, then the seafarer's employer is exposed to criminal penalties, applying all the usual constructions applicable to criminal legislation. We say that can't be right when you're looking at an obligation simply to allow paid leave. That is only infringed if you don't allow the leave or you don't pay for it, at least at some minimal level. It cannot be the case that Parliament intended employers of seafarers to be at risk because they didn't include some allowance which might or might not be paid in a given week. And we say if that's true for seafarers, it must be equally true for aviation workers. And we say, certainly as a matter of domestic construction, that there is simply no reason why paid should not be given its obvious core meaning. Whenever penumbral cases may arise, this is a simple case. To pay basic pay, some £2,000 a week, is paying paid leave. No aviation worker would say that his leave is unpaid. And we say that as a matter of domestic construction, the position is really beyond argument, not only because of the language of the regulations, but also because of their history and interrelationship. Can I then move to the directive? Address the question whether the directive affects the position. The first point to make, I hope is not too trite for the Supreme Court, is that we are concerned with a directive. And under Article 149 of the former Article 189 of the treaty, a directive is binding as to the result to be achieved on each member state to whom it's addressed, but shall leave to the national authorities the choice of form and methods. This means what it says on the tin. You have, in fact, Article 249 in tab 12 of your authorities bundle. And I'll just take you to that. It's right at the back of tab 12, on the reverse side of the final page in that tab. In order to carry out their task in accordance with the provisions of the treaty, the European Parliament, acting jointly with the Council and the Commission, shall make regulations and issue directives, take decisions, make recommendations and deliver opinions. A regulation shall have general application. It shall be binding in its entirety and directly applicable in all member states. And that's in contrast to the directive, which is binding only as to the result to be achieved, but leaves to the national authorities the choice of form and methods. So it's implicit in its being a directive rather than a regulation, that it is not general and binding in all its provisions. All it is a direction to member states to achieve an overall result. Second, rather basic point, of course, is that it's a directive which implements an agreement, not one which enforces an independent norm. Now, my Lord Mance has already made the point that we don't know a great deal about the discussions which led to the agreement, though we do know from the Tribunal's finding that the question of pay was not high on the Union's agenda. This wasn't, realistically, a matter of concern. We can turn to the directive itself, tab 17. It's important to underline its recitals, and its recitals reflect similar recitals we've already seen in the Seafarers Agreement. First of all, recital 8. This directive and the agreement lay down more specific requirements within the meaning of Article 14 of Directive 93/104 EC as regards the organisation of working time of the mobile staff in civil aviation. That's the provision which triggers the exception in the original working time directive. And then recital 10, the proper instrument for implementing the agreement is a directive. 11, in view of the highly integrated nature of the civil aviation sector and the conditions of competition prevailing in it, the objectives of this directive to protect workers' health and safety cannot be sufficiently achieved by the Member States, and community action is therefore required in accordance with the subsidiarity principle, come to that later, laid down in Article 5 of the Treaty. This directive does not go down beyond what is necessary to achieve those objectives. 12. With regard to the terms used in this agreement, which are not specifically defined therein, this directive leaves Member States free to define those terms in accordance with national law and practice, as is the case for other social policy directives using similar terms, providing the same definitions are compatible with the agreement. And it's important to say that recital 12 does not appear, and no analogue of it appears, in the Working Time Directive itself. There is an additional layer of discretion which is expressly confirmed or conferred in the Civil Aviation Directive, which is not applicable to the Working Time Directive generally. Two specific points on Regulation 12. First, of course, in providing that Member States are free to define the terms, it's necessarily implicit that they are free not to define them and simply to incorporate the terms in internal regulations. And that the only limitation, this is the second point, is that the definitions have to be compatible with the agreement. So that there's no requirement that the definition has to be compatible with any other community measure. Simply has to be compatible with the terms of the agreement. Clause 3 of the agreement, which is given effect, as we've already seen, contains no definition of paid and no threshold requirement. And we say, looking at clause 3, that it's unthinkable that it was laying down some prescriptive requirements as to computation. Indeed, the language is completely to the contrary, because it reinforces discretion and subsidiarity by providing that the paid annual leave of 4 weeks is to be in accordance with the conditions for entitlement to and conditions and granting of such leave laid down by national law and practice. It expressly allows member states discretion in setting out the conditions of leave, and that must include the pay conditions. And one can test it the other way around. If the aviation regulations had chosen expressly to define pay as excluding allowances, which might or might not have been received in a given week, it would plainly have been exercising freedom of definition. The freedom of definition is simply meaningless if it's not open to member states to exclude or include particular allowances. And we say that to say that pay must include this allowance or that allowance would strip the discretion of meaning. It can't have been intended. The European Court made the point in the UK against Council case, a case where the United Kingdom challenged the validity of the Working Time Directive, that the enactment of detailed implementing provisions was left largely to member states. And I would just like to read you paragraphs 46 and 47. It's Authorities tab 44. And if one goes to the judgment at 506 to 507, may be helpful for a related purpose in a moment if I start at 445. Since it's clear from the above considerations that in terms of its aim and content, the directive has as its principal objective the protection of health and safety of workers by the imposition of minimum requirements for gradual implementation, neither Article 100 nor Article 100A could have constituted the appropriate legal basis for its adoption. This is dealing with the United Kingdom's argument. The United Kingdom further maintains that the community legislature neither fully considered nor adequately demonstrated whether there were transnational aspects which could not be satisfactorily regulated by national measures, whether such measures would conflict with the requirements of the EC Treaty, or significantly damage the interests of member states, or finally, whether action at community level would provide clear benefits compared with action at national level. In its submission, Article 118A should be interpreted in the light of the principle of subsidiarity, which does not allow adoption of a directive in such wide and prescriptive terms as the contested directive, given that the extent and nature of the legislative regulation of working time vary very widely between member states. The United Kingdom explains in this context, however, that it does not rely on infringement of the principle of subsidiarity as a separate plea. In that respect, and here we get to the Court's conclusions, it should be noted that it's the responsibility of the Council under Article 118A to adopt minimum requirements so as to contribute through harmonisation to achieving the objective of raising the level of health and safety protection of workers, which in terms of Article 118A1 is primarily the responsibility of the Member States. Once the Council has found that it's necessary to improve the existing level of protection as regards the health and safety of workers and to harmonise the conditions in this area while maintaining the improvements made, achievement of that objective through the imposition of minimum requirements necessarily presupposes community-wide action, which otherwise, as in this case, leaves the enactment of the detailed implementing provisions required largely to the Member States. This point's being made in the context of working time. The argument that the Council could not properly adopt measures as general and mandatory as those forming the subject matter of the directive will be examined below. But what we underline is the 2 lines just below letter B, that it leaves the enactment of detailed implementing provisions required largely to Member States. Allied to this point, of course, is the fact that the measure is a health and safety measure, so that there is really no reason to suppose that it is intended to be prescriptive in relation to the detail of pay. The pay requirement, as I think your ladyships have already observed, is really only a means to an end to ensure that the leave is taken. And one gets this, for example, from recital 11. It just goes back to that for a moment to tab 17. Emphasising that, in common with the General Working Time Directive, it's a health and safety measure. I hope your lordships haven't put away the UK and Council case, because this was clearly underscored in the United Kingdom's action against the Council. It sought to strike down the Working Time Directive as not having been properly made under the health and safety provisions. And it was in general unsuccessful, but it did succeed in striking down particular provisions in the original directive which were concerned with Sunday working. The European Court said, well, Sunday working has got nothing to do with health and safety. That's a social matter. That's not a health and safety matter, so it goes out of the directive. And the European Court at paragraph 22 sets out its basic conclusion that the measure as a whole was valid because the principal aim of the measure in question was the protection of the health and safety of workers. Article 118A may be used, albeit such a measure may have ancillary effects on the establishment and functioning of the internal market.
Does history record this was passed by qualified majority voting, this measure? Was it the UK presumably outvoted?
Yes. And it was because this particular, because action in relation to health and safety could be passed under majority.
There was the difference between Article 100 and 118A, wasn't it?
Exactly. So that was the basis on which the United Kingdom government sought to challenge it. But as regards to Sunday working, if one goes to paragraph 37, As to the second sentence of Article 5, whilst the question whether to include Sunday in a weekly rest period is ultimately left to the assessment of member states, having regard in particular to the diversity of cultural, ethnic and religious factors in those states, the fact remains that the Council has failed to explain why Sunday, as a weekly rest day, is more closely connected with the health and safety of workers than any other day of the week. In those circumstances, the United Kingdom's alternative claim must be upheld, and the second sentence of Article 5, which is severable from the other provisions of the directive, must be annulled. And goes on to uphold other provisions of the directive because they are health and safety measures. The Court of Appeal here developed this theme in the Bamsey case. Bamsey is volume 2.
Well, unless Bamsey is very quick, it might be best to leave that till tomorrow.
Yes, indeed.
10:30 tomorrow then.